Okay. Let's start the last talk in this session. Our speaker will be Van Lindberg, and he will give us a talk on untangling data ownership. So, please welcome him.
So I've got about an hour and a half worth of stuff. I've got 25 minutes to really present it to you. So I'm going to talk a little bit fast, but we're going to go through as much as possible. I know that at least half of you here are because you're data ownership nerds. For the rest of you, I figure, why do you want to worry about this? This is part of the PyData track. And so I figured that a lot of you may think, what are we going to do with all this data? And so I figured that, especially here, we would start with a quote from Sir Walter Scott. Let's see. Okay, there we go. At least one person got it. So what is data ownership? Well, before we get there, let me just say, a lot of times, when we think about big data, we always tend to think more data is better data. And there was a very interesting paper that was published a long time ago called The Unreasonable Effectiveness of Data. And the basically thought of this was, the more data that you have, the better decisions you can make. The better decisions you make, the more valuable your decisions are. And so the entire thought of big data since about 2007, 2008, and just accelerating, is that when we are able to have all this data, we're able to map all these various inputs onto a set of outputs, and we're able to do really interesting things. But this is about why you may want to throw away or hide or not use certain types of data. So let's talk about data ownership for a second. Data ownership is about both the possession and the responsibility for information. Ownership implies both power and control. And the control of information includes not only the ability to access or create or modify or package or do all sorts of other things with the data, but it's also the ability to assign these privileges to others. And these rights are typically based in law. So let's start at the very, very bottom at who owns a fact. Now I'm going to start by giving you the absolutely precise and lawyerly answer. Now, of course, this absolutely doesn't help you one bit. So I will start by saying that a lot of times bare facts alone, are not ownable under law because they are a representation of reality, and no one really owns reality, at least not yet. They're working on that. It's called VR. But let's talk about, but a lot of times we're not talking about a single fact, we're talking about collections of facts. And so we're going to think about what happens to the claim. Who is able to claim that they own particular facts? And it really depends upon the role that you have when you are interacting with this fact. All of these different types of roles actually are associated with different types of rights. And when you think about data ownership, I want you to think about it in a very specific way. When you think about ownership, you think about, I hold this thing, I possess it. But you don't really possess data in that same sense. I mean, maybe you have a copy of it on your hard drive or wherever. But you should be thinking about it in terms of duties that are owed. And essentially, if a claim for data ownership is a claim that there are duties owed according to that, to somebody associated with that data. Or if you assign it out, then there will be duties owed to you. And it's this chain of duties that are enforceable in law, which really is what gives rise to this idea of data ownership. Again, because we're talking about some, to a certain extent, representations of reality. And there are, when we bring these things together, it is really about whose duties are owed to whom that really make things, that really stuff things up. So let's think, for example, about an example of a medical record. So the question is, and I'm going to give you the US answer, and then we'll talk about the UK in a second. One of the areas that people do a lot of work on in big data is medical records. So who owns a medical record? Shout it out. The patient. Patient? Maybe. Who else could own the medical record? Say again? The hospital? Anyone else you think of? The government? Well, the answer in the US is it depends. That one little state up there in green is the state that has explicitly said that patients own their medical records. The states in purple are the ones that say that the doctors own the medical records, and the states in gray are the ones that say, we have no idea. So I said we would talk about this for a minute in the UK. Surely this is going to be easier in the UK. Almost all of your healthcare goes through the NHS. Who owns a medical record in the UK? Who do you think? No one really knows. So, generally speaking, just so you happen to know, the notes made by an independent professional person remain the property of that person, regardless of the use to which they may put the information that they contain. So, basically, a doctor owns the doctor's notes. But most people don't, including doctors, they don't work alone. And so a specialist who, as a member of the staff, treats patients not in a direct contractual relationship with that contract, does not own the medical notes relating to the patient. The legal position of who actually owns it is not exactly clear. There are about 4 different laws in the UK relating to access to this data, saying that the government has a right of access, other people may grant access. You, as an individual, may have the right to view your medical records, although they don't really publicize this right too much, and the doctors may ask up to £50 for the privilege for you to look at your own record. But, and there's duties associated with the confidentiality of these records, but it is not actually clear who owns the medical record in the UK. Isn't that fun? So let's talk about something near and dear to my heart. Who owns a legal brief? Anyone know? The lawyer? Any other thoughts? The person who paid for it? Again, what's the lawyerly answer? It depends. That is absolutely correct. A lot of times, the client is the one who's considered to have possessory information for anything that is turned over to the client because they paid for it. But the lawyer's notes themselves are generally owned by either the client or possibly by the firm, depending upon the contractual relationship between the lawyer and the firm. And what about things that are actually filed with the court? Interestingly enough, a lot of places, those are not considered to be ownable because those are functional documents. And so you'll find that lawyers are terrible plagiarists, and they will steal arguments and entire text from previous legal briefs, and they're like, this is functional language, it is absolutely mandated more or less by law, and so it's not actually covered by anything legal. So let's talk about something that is a little bit different. What about collections of facts? Like a database. Any thoughts on that? You all are learning very, very fast. Well, it comes down to most of Europe actually has laws that grant a database right. And here in the UK, there are two different types of rights. There's both a database right and a right that is enforceable under copyright law. So these laws are designed to actually protect the work that went into collecting and correlating and allocating this data. And so you are allowed to say, I spent a bunch of time and effort putting this together. This is my unique contribution to the world, and you are able to have that persist. The database right here in the UK is good for 70 years after creation. Just so you know, because a lot of people don't interact with the United States doesn't actually have a concept of database rights. A lot of the times those things are protected under a trade secret type of regime. But one of the things that goes on, and this is a particularly US-focused story, but it's one of my favorites. A lot of times what people would do in order to protect a collection of facts under US law was to introduce creatively various errors into it. And the thought was, by looking at these errors, those were their unique creative contributions, and because they had this, and if people copied the errors, you knew that it was going to be, that it had been copied, and they would be able to enforce things. And the classic example in this was maps, because all accurate maps look like each other, correct? And so it's really hard to prove that someone copied your map. Well, my favorite story about this is set in New York. Two map makers had just finished collecting geographic data for a new map of New York State, and they thought, this is the best map that has ever been made. And so what they did is, in order to prove that someone had stolen their map, they decided they located this little spot where two roads came together, and they combined their initials to make the word Aglo, and they labeled this little spot Aglo. Any other map makers that copied the map, including Aglo, they could prove were plagiarists. And then one day a man came and he decided to set up a general store. And he came to the spot, he's like, this is a good spot to set up a general store. What's this place called? He looked on the map and said it was Aglo. And so he set up the Aglo General Store, and in later time, a few other people came around it, and it became the hamlet of Aglo. Fast forward about 50 years, and Rand McNally, who you might have heard of, saw someone else had copied their map because it had Aglo on there. And turns out that when it went to court, they actually said, look, there are actually people living in Aglo. There's a hamlet, Aglo, because this is now a true fact. It is a representation of the world. It is no longer something that you purely made up. It is, and so they were able to get the case dismissed. We don't actually know whether they plagiarized or not, but that was one case in which simply naming the place caused it to exist. Well, how about contracts? Contracts are agreements between two people that give right to various, give rise to various rights and relationships and duties. Again, ownership is all about what duties you owe one way or to the other. There's actually big news here. For those who are working in open sourcey type contexts, for a long time, the open database license from OpenStreetMap was the big copyright, or the big open data license. Just a week or so ago, the Linux Foundation launched two varieties of community database licenses. One that is designed to encourage people to reciprocate in terms of donating their facts back, and one that is designed to be very, very permissive. You also may have heard of the Creative Commons licenses, which are also frequently used for this sort of data. The final thing I want to talk about which is useful both almost anywhere in the world, is trade secrets. And trade secrets are anything that is kept secret and has financial value because it is kept secret. So customer lists, what you had for dinner. Actually, if you keep a consistent list of what your customers had for dinner, that's a trade secret because someone could have use and get value out of that. So that brings me to this next big issue is, all right, you've got all these people who can possibly own data. It's unclear to know what all those different rights are simply by looking at the fact, because there was this great essay about 2004 or so called "What Color Are Your Bits?" And the thought was, this is not just about the specific representation of a fact or the specific representation of a particular concept. It is about where did you get it from? And that's what brings me to data provenance. Data provenance is about the way in which you know a fact, not just the fact that you know it. And so my favorite story associated with this came from when I was helping a defense contractor who was using various amounts of open source, and I did not have a top secret clearance, and these were top secret things. And so what they did is they would give me a list of open source projects that they were using, and then they would ask, what are the sorts of duties that we have to deal with this? And so one of the package listings that they gave me looked like this, and I looked at them and I said, by the way, this is incorrect. This is probably incorrect. Can anyone spot why I thought that?
There's no equals. It's bigger than the license can change.
It's not that's a good thought, but it's actually not the version. One of these is not like the others. Specifically, it's this one. The rest of these have to do, and I said, how do you know one of these is wrong? I said, this one doesn't fit. And the reason why is because they're like, so how do you know? I said, well, let's look at this application that you're putting together. You've got, standard, you've got your C libraries, and then you've got some data storage, and you've got some secure connections. And then you've got various things where you're talking back and forth. You've got codecs, and you've got chat things. And then in the middle of this, you've got a standalone word processing suite. Your application is not likely to incorporate both essentially chat aspects and also be tightly integrated with LibreOffice. And the person who was in charge of security, as I was explaining this, the color drains out of her face. And she says, can you excuse us? And we went out, we came back in, all those papers had gone in the burn barrel. And they said, we're going to need to continue this at some other time. Because simply by representing a series of facts together, specifically the facts associated with what kinds of libraries they were using, they communicated something about a top secret project that they did not intend to communicate. And as a result, from then on, they took away both the project identifier and scrambled the order of everything so that there was no association of different projects with different items. But turns out that this was specific. This is what happened is I happened to know a fact that they had communicated, and I was able to explain why my knowledge came from a particular area. And so the fact that I knew that certain things worked together, that was okay, but the fact of their grouping had driven this. So, oh wow, I've only got 5 more minutes. So let's talk for a second about collections of facts. How many of you are aware of the reproducibility crisis in science? This is entirely about data, and really the ability for people to reinterpret data and look at it. So I'm going to actually skip ahead because I want to give you something very, very concrete. When you are dealing with your data flows, the thing that you want to do is you want to say, you are going to need to, by default, you will always have duties associated with your data. And what's going to happen here, and what is happening already, is that especially here in the UK, and is you're going to have the General Data Protection Regulations, which mean that if you collect anything associated with a person, even if it is not explicitly about a person, or you combine different data sets in ways that could be used to identify a person, even if you don't identify the person, then you are a data processor and you can be subject to fines. So the question is, how do you make sure that you are clear? The idea is that you need to build in data provenance tags into your workflow, because you can, by either bringing things together or splitting them apart or veiling the data, you are able to either create or extinguish some of these duties, and in doing so, either subject yourself to liability or free yourself of liability. And one of the key examples is I was working with the bank, and they were talking about how they were trying to do broad level identification of customer trends. And they had credit card data, and they were flowing through their big data pipeline representations of who the people were who had made these various transactions. And they were very, very worried because very soon they were going to be subject to liability associated with those data flows. And so they realized that in the end, what they were doing is they were matching up various generic profiles of people and not specific people. And so what they were able to do is very, very early on, both swap out all the identifying information for an opaque GUID, and then to map those GUIDs to classes of customers. And in doing so, they were able to prove that it was a one-way transform. They weren't able to get back to the original information. They were able to cut off their liability by tracking how far that they went through, how far this data went through their pipeline. There was another example where someone else had information information about zip code, about postal code, and they were bringing this together with information about use of various services, and bringing these two pieces of information together, even though they weren't tied, actually gave rise to the ability for somebody to de-anonymize the data and identify people within not super well, but closely enough that it actually made them subject to regulation. So you have to understand, whenever you combine data, you want to understand, does this give rise to a duty? And number two, you want to extinguish those duties as early as possible so that you are not subject to regulation. And I've got so I could either give you the wrap up. I'll give you the wrap up, and then I'm going to talk to you for a second about GDPR if I've got any time. So number one, evaluate data ownership claims when you identify your data. You've got to know where you got it from and what duties are required. And the second is tag your data and use it throughout your flows, because the metadata is really about making sure that you're either extinguishing or giving rise to these particular duties. And number three, there are data enrichment services which are specifically associated with correlating different types of data and providing you a richer view, typically of the people associated with those data. Those things are explicitly going to be regulated. You need to be very, very careful with them. Why is this an issue? For the UK and for the EU, the big thing that you're going to need to look at, just very concretely, is the GDPR. It's going to come into effect here in Britain on May 25th of next year. They're already ramping up it is up to 4%. They can levy fines of like 20 million euros or 4% of global revenues, whichever is larger, which is a pretty substantial fine. They're already levying fines, getting people ready for that level of enforcement. You think, hey, I'm in the EU, or I'm in the UK, Brexit will save me. No, it won't. First of all, Brexit is going to happen after the GDPR applies here. Second, in order to maintain trade relations with Europe, the UK is actually in the process of adopting regulations that are in some ways even more stringent than the GDPR requires. The GDPR covers anybody who is processing data, which is, GDPR defines that very broadly. It is collection, recording, organization, structuring, storage, adaptation, or alteration, retrieval, consultation, use, disclosure by transmission, dissemination, or otherwise making available, alignment or combination, restriction, erasure, or destruction. So can you identify something that you can do with data that is not processing the data? Probably not. If you have a contact list, you are processing data and you're subject to the GDPR. A data controller is the one who defines the purpose. The data processor is the person who does it. You may be subject to both. There are separate regulations. There are very stringent privacy restrictions associated with it. If you're going to be doing this sort of data and it is in any way associated with a human, make sure that you're covered by doing these things. And I'm happy to answer questions. But I am out of time, so I shall say adieu.